For this third station, I kindly invite Honorable Ladyship Srimati Anuja Prabhudesai, Judge, Bombay High Court and Member, Mediation Monitoring Subcommittee, Mumbai, respected Shri Rajiv Patil, Senior Advocate and Mediator, respected Shri A. Subramaniam Sir, Principal District Judge, Yavatmal, on the dais. I request Honorable Ladyship Srimati Anuja Prabhudesai to welcome respected Shri Rajiv Patil, Senior Advocate and Mediator, by offering a sapling. Thank you, Honorable Ladyship. I again request Honorable Ladyship to welcome respected Shri A. Subramaniam, Principal District Judge, Yavatmal, by offering a sapling. Thank you, Honorable Ladyship. Now, we will proceed towards presentation on the topic New Ideas and Concepts in Mediation and Change of Approach by respected Shri Rajiv Patil, Senior Advocate and Mediator. I kindly request Sir to start his presentation.
Good afternoon, everybody. I hope PPT is ready. After the lunch, within few minutes, I am just trying to present my presentation about new ideas and concepts in mediation and change of approach. Considering all the time we are listening and hearing about the mediation, it's a right time now to have new ideas and some change in our approach so far as the mediation is concerned. The people are changing. The issues are changing. My friend who is the senior mediator who is present over here, Ms. Tanu Mehta, in the morning informed me that she is invited by Army College for the purpose of training in mediation. So people are changing their modes. It's not meant for court martial, but it is for the purpose of some civil dispute in remote areas of India like Nagaland. Now, when we talk about mediation, there are too many difficulties with too many ideas. And it requires change in approach so far as the mediation process is concerned. Why I am saying this? Because all the time we are just considering the mediation in terms of only family law, family dispute. We need to change that concept because mediation is not restricted to the family disputes or the family laws or the property dispute within the families as such. We need to look at the commercial disputes, the other areas where the mediation can work. And therefore, it is necessary for us to change our concept so far as the mediation process is concerned. We have to change our setup that mediations means family dispute. We need to change our role plays that mediation means family disputes. And therefore, it will be necessary for all of us to consider these changes which are coming day by day with new ideas. Now, I am just trying to place before you the difficulties in the matter of trying to process or initiate this mediation process. You may not, or many of my advocate friends may not like my first difficulty because I am saying something about the advocates. When advocates promote mediation, it is a good side, it is a not good side also. There are difficulties. Because sometimes advocates come with an honest intention to resolve the dispute at the initial stage. But sometimes, of course, I am from the legal fraternity, advocates community, and I know what happens in our mind when we see that there is no possibility of getting some kind of a relief in the court of law. So we proceed with the mediation. We proceed with the mediation with the idea that if at all I delay the thing, then in that case it may help me from facing an adverse order. So therefore needs to be the sensitization in the advocate community about this process. One needs to have these difficulties come when it comes to the commercial disputes or the matters with the financial stakes, where advocates don't want to take a risk or the clients don't want to take a risk. So the idea of a litigant or an advocate, I won't say it's a litigant's idea to delay the thing, but we are also equally responsible for the purpose of seeing the net result of the mediation process. One more aspect I faced in all these years, because I am associated with this mediation process since 2005, and it comes to some advocates have different ideas. Why I am telling you this? Because you are the presiding officer and you know what is my role in the entire process. We need to sensitize not only advocates but also the judicial officers. For this reason, it is not the forum for the advocates to advance their ideas. It is the forum for the clients, for the litigants to advance their ideas. This is what comes to my experience is this. I asked advocates to remain present in the mediation process, no doubt about it, because it is assistance, along with their client, but I believe in promoting a dialogue with the parties without referring to the legal provisions of law. I don't want to scare the person by saying that this is the law and this is what you should do. Or I don't want to make him aware that he is kind of under an obligation to too many provisions of law. We request the parties to open their mind to end the litigation, not to extend the litigation, and to persuade the parties to take a decision on their own. Parties tend to depend on a legal advice. Parties tend to depend on a advice given by a person who is supporting the litigation. But parties never have a confidence that she or he or them can take an appropriate decision in respect of their own rights or own claims. The third difficulty which I am facing is, this is what my personal experience is, in respect of online mediation. So far, online mediation, I am not aware about the data. However, it has a restrictions according to me, a time restrictions. If at all it is referred to the advocates who are litigating advocates in the court of law, they have time limitations. It is difficult to assess the parties about his willingness to reach the resolution or solution. So therefore, according to me, the online Mediation has its limitation. It may work if at all it's a full-time, full-fledged mediator involved in that, giving maximum time and allowing parties to open up. The one more difficulty which I came across, not with me, but my colleagues in the mediation process, they say something about the freedom of mediator. Freedom of mediator is that allow them to do and proceed with the mediation process with their full liberties. We cannot have a time schedule at a district places or the civil court places where the regulatory body like mediation center is supervising the progress of mediator. Mediator can't be put under the kind of a time frame or kind of a schedule or kind of a areas where it can be supervised. There is always an insistence to complete the mediation in a particular time and submit report. It is my colleagues who are practicing in the civil courts other than the High Court, they also always feel that the court or the mediation center is asking for the report at the earliest, and we need to work on that. And therefore, I say that one need to give a maximum freedom to the mediator to communicate with the parties. The fifth difficulty. I am not here with full of difficulties, but I am here with the difficulties which allow us to consider the aspect where we can improve our mediation process. Fifth difficulty is non-availability of infrastructure to hold mediation process. Pardon me, of course, at the High Court level where I sit in a mediation process, there is a maximum facilities available, no doubt about it. But while having a role play, you saw a mediation center, how equipped it was. Is it really today? It is not. In our city civil court, Mumbai, there are few cubicles which allow the mediator to sit at a particular time. But it needs the facilities like if at all you are going online mediation process, it needs a kind of a video conference facility. It needs the stenographer who can take the notes. I am not saying that a mediator is a kind of a judicial officer, but sometimes it is required that some notes are to be taken. Photocopy machines, because the clientele feel that they need to have this kind of a facility because they want to submit something. And these are all the facilities which should be available at the mediation center, and therefore we need to work on this, because unless we work on this, we are not going to come out with the new ideas and new concepts. There are other issues that advocates who are mediators exclusively in mediation as an exclusive profession, and litigating advocates who are doing the mediation process. Person who is exclusively in mediation, like Mr. Popat here, he is present here. He has all the time at his space to deal with have a dialogue with the parties to come to a resolution in minimum time, whereas it is not possible for a litigating advocate to give this maximum time, which needs to be considered. I came across some issues which are relating to NGOs, non-governmental organizations. Non-governmental organizations also extend their help to go for a mediation, but it is my personal, honest and humble opinion is this: NGO promoting certain causes and try to become a mediator, but they are unable to reach the solutions because they have their definite ideologies and concepts about the issues. There is one more aspect which you can consider. I am not asking for, please don't misunderstand me, that whether I am promoting a dialogue between mediator and judge. But I am trying to say that if at all a judge who refers the matter for mediation can have a confidentiality in respect of the mediator who is working on the issues. It needs to be, after the mediation process is complete, it needs to be value that particular mediation settlement, and there has to be an attempt to execute that mediation settlement in a proper manner. The last issue which I am coming to is a pre-institution litigation mediation. Sorry, sirs and madams, today as of in Bombay High Court, we see the pre-litigation mediation, the parties reach there as matter of formality. It's a kind of a, because it is introduced in bill, or it is likely to become a law, or it is a part of act, people do file their claim, but people are unable to reach the mediation center in any manner to have this kind of a process to be proceeded with. Pre-institution litigation needs to have a more, because according to me, every issue has its own time to realize that we need to go for a mediation process. At the time of inception of a litigation, the blood is running high, the rights are very clear in the minds of the parties, and they try to assert their claim, rights, at the time when they initiate the litigation. Now, pre-litigation mediation, if at all it becomes a formality to be completed, then in that case the goal is not achieved. And therefore, there has to be some different mechanism so far as the pre-litigation mediation is concerned. Now, I am coming up with a new approach. There needs to be a complete communication or exchange of thoughts between mediators who are exclusively in mediation as exclusive profession, and there are litigating advocates who give their time to mediate the disputes. Now, we need to give a leeway somewhere to the persons who are available for a limited time in a mediation. It can't be a strict rule that you have to end a mediation in a particular time, 6 weeks, 8 weeks, or 12 weeks. I came across a provision in new mediation bill, though it is not a subject matter of today's presentation, that if at all on the second time if party fails to come before the mediation, then in that case there is a possibility of drawing adverse inference against the party who is not attending the mediation process. According to me, it can't be, because you have to persuade or convey the parties to approach for a mediation process. As I said earlier, that NGOs have their own ideologies fixed, and therefore they can't be a good mediator. I spoke about the confidentiality and the dialogue which is between the litigation and mediator, and I also spoke about the valuation and execution of mediation settlement. I suggest this and I follow this. If the parties resolve their issues, I just write down the minutes and I forward it to the court, because parties are always under the impression that we are not signing consent terms, that we are going back to the court and our mediation report is going to be finalized by the court, which is binding on them. And that is what I feel it is necessary to be considered. Though I spoke about the pre-institution litigation, and therefore we need to work on this issue of pre-litigation mediation. It may not be a complete answer by mediation bill, but I just placed my thoughts before you for your kind consideration to ponder upon, and I hope this will be a piece where I can contribute to the process. Thank you.
Thank you, sir, for giving your valuable practical insights on today's topic. Now, I invite respected Shri A. Subramaniam, Principal District Judge Yavatmal, for his presentation on the topic matrimonial mediation, potential challenges and way forward.
Good afternoon, honorable members, honorable dignitaries on the dais and off the dais, my dear fellow judges, as well as the law students who are present here. It is really a very interesting subject that is brought forth, is matrimonial mediation, its potential challenges and way forward. तसं पाहिलं तर मी पुणेकरांनी पुण्यात येऊन मराठीत नाही बोललं तर त्रास होईल म्हणून थोडंसं मराठीत बोलतो. मीडिएशन ही जी कन्सेप्ट सुरुवात झाली ही जास्त करून कमर्शियल डिस्प्यूटसाठी सुरुवात झाली, इन्शुरन्स केसेससाठी सुरुवात झाली. आता मग हे मीडिएशन मॅट्रिमोनियल डिस्प्यूटमध्ये का चांगलं आहे ह्या गोष्टीचा आपण विचार करायला पाहिजे आणि मग त्याच्यात काय बदल करता येईल ह्या गोष्टीचा आपण विचार करू शकतो. जर एक छोटीशी मॅट्रिमोनियल डिस्प्यूटचं जर आपण वाद बघत बसलो तर आपण एक बहिणाबाईंची आहे एक हे आहे त्यात जर बघितलं तर त्यात म्हणतात अरे संसार संसार, त्याच्यात असं एक सगळ्यांना माहिती असेल तर त्याच्यात असं आहे, एक संसार दोन जीवांचा विचार, देतो सुखातले नकार आणि दुःखातले होकार, देखा संसार संसार दोन्ही जीवांचा सुधार, कधी नगदे उधार सुखदुःखाचा बेपार. सो लॉंग टाईम बिफोर म्हणजे बहिणाबाईंच्या काळापासून जुन्या काळापासून आपण बघाल तर संसाराला एक सुखदुःख, एक देवाणघेवाण, एक कुठेतरी वेगळं स्वरूप देण्यात आलेलं आहे. हे कुठल्या तरी रुटीन व्यवहारासारखं नाही आणि एक रुटीन गोष्ट नाही. सकाळपासून सगळ्यांनी पुणे तिथे काय उणे हा शब्द वापरला तर मॅट्रिमोनियल डिस्प्यूट बाबतीत सुद्धा पुणे तिथे काय उणे आणि त्याच्यासाठी एक लँडमार्क केस आहे दास्ताने वर्सेस दास्ताने. मला वाटतं ज्यांनी फॅमिली कोर्ट किंवा मॅट्रिमोनियल डिस्प्यूट कधी हाताळला असेल ही केस प्रत्येक वेळेला प्रत्येक केसमध्ये साईट झालेलीच असेल. या केसचं विशेषतः म्हणजे ह्याच्यातलं जे ट्रायल कोर्ट होतं ते आपल्या पुण्यातलं ट्रायल कोर्ट होतं. हा जो वाद तयार झाला होता, हा वाद जो झाला होता ते 1961 साली त्यांनी या दोघांनी पती पत्नी वेगळे झाले. त्यावेळेला माझा जन्म झाला नव्हता. 1964 साली त्यांची ट्रायल सुरू झाली, त्यावेळेला सुद्धा माझा जन्म झाला नव्हता आणि शेवटचा जो निकाल ऑनरेबल सुप्रीम कोर्टात झाला तो 1975 साली झाला, त्यावेळेला मी फक्त 5 वर्षाचा होतो. आज जवळजवळ 50 वर्ष झालीत या निकालाला आणि आज आपण त्या निकालातले प्रिन्सिपल्स किंवा त्या निकालातले जे गाईडलाईन्स आहेत, त्या निकालातले जे विचार आहेत ते आज प्रत्येक मॅट्रिमोनियल डिस्प्यूटला आपण वापरतो. तर ह्या 50 वर्षात काही बदल झाला का मॅट्रिमोनियल डिस्प्यूट्समध्ये? ह्या 50 वर्षात मॅट्रिमोनियल रिलेशनशिपमध्ये बदल झाला का? आणि जर एवढी सुंदर सिस्टीम आणि एवढी सुंदर ॲड्ज्युडिकेशन किंवा एवढे सुंदर गाईडलाईन्स आपल्याला जर असतील तर मग मीडिएशनची गरज काय? हा एक महत्त्वाचा विचार आपल्याला नक्की विचार करायला लागेल. तर आपण त्याची उत्तरं काही गोष्टी दास्तानेच्या केसमध्येच आहेत. तर त्या ह्याच्यात ते म्हणतात की ॲक्ट्स ऑफ द पाऊस विच आर कॅल्क्युलेटेड टू इम्पेअर द इंटिग्रिटी ऑफ मॅरिटल युनियन हॅव सोशल सिग्निफिकन्स. नवरा बायकोचा वाद हा काय एकट्या नवरा बायकोचा वाद नाही, तर त्याला सोसायटीचा सगळा वाद तयार होतो आणि ते ऑनरेबल सुप्रीम कोर्ट म्हणतं सोसायटी हॅज अ स्टेक इन द इन्स्टिट्यूशन ऑफ मॅरेज. So it is not an individual dispute, it is a social dispute. And therefore the erring spouse is treated not as a mere defaulter but as an offender. हे खूप महत्त्वाची गोष्ट आहे की ह्याच्यात मी राहिला होतो त्यावेळेला इथं भारती विद्यापीठमध्ये फॅमिली कोर्ट होतं आणि त्याच्या डायगोनली नदीच्या अपोजिट आम्ही राहिला होतो. तर बरेचशी लोक जुनी लोक जी आहेत, भारती विद्यापीठची बिल्डिंग आली की रस्ता क्रॉस करायचे, पलीकडनं जायचे आणि मग परत या बाजूला रस्त्याचे यायचे, कारण भारती विद्यापीठच्या बिल्डिंगवरनं आम्ही जाणार नाही, कारण तिथे लग्न मोडली जातात, एक नाती तोडली जातात, हे एक विचार पुण्यातल्या लोकांचे असायचे. सो दॅट इज हाऊ इट इज अ सोशल दिस इज देअर. In many cases, each party can, if it so wills, discover for complaint, but such grievances arise mostly from disharmony. So this is what is an important aspect relating to matrimonial dispute. Further, in Bhuvan Singh's case, it says that delay in adjudication of such disputes is not only against human rights, but also against basic embodiment of dignity. So this is the importance given to a matrimonial dispute that has happened. The last part is also important. The procrastination is the greatest assassin of lists before it. It not only gives rise to more family problems, but also gradually builds unthinkable and ever-staying bitterness. It leads to cold refrigeration of the hidden feelings if still left. This is what we always see in matrimonial matters. That is always there. The latest ruling of G.V. Rao says that there are many reasons which need not be mentioned here for not encouraging matrimonial litigation. It's a very interesting fact that as a judicial system we say that we should not encourage matrimonial litigation, so that the parties may ponder over their defaults and terminate their disputes amicably by mutual agreement instead of fighting it out in the court of law, where it takes years and years to conclude, and in that the parties lose their young days in chasing their cases in different courts. This is a start of process of amicable thinking that has been brought up. A drastic change in matrimonial disputes came in the case of K. Srinivas versus D.A. Deepa, where 498A is now made amicable to mediation. Important observations we can see is there is hardly any dispute where one spouse is entirely at fault. Dispute always assumes alarming proportions. We'll see another part where it is highlighted. If the parties are sent to mediation center, or if they had access to pre-litigation clinic, perhaps the bitterness would not have escalated. Things would not have come to such a pass if the earliest someone had mediated between the two. The Honorable Supreme Court further holds, the cause of misunderstanding in a matrimonial dispute is trivial and can be sorted out. At the earliest stage, it must be referred to mediation centers. Matrimonial disputes are preeminently fit for mediations. The concept of two concepts, new concepts that have been brought about, चला बोलूया किंवा लेट्स टॉक आणि सुकून हे जे इन्स्टिट्यूट्स आलेत हे ह्याच्यात एक पार्ट आहे या जजमेंटच्या आधारे. आणि शेवटी ऑनरेबल सुप्रीम कोर्ट होल्ड्स, we recognize mediation as an effective method of alternative dispute resolution in matrimonial matters, and that is the reason why we want the parties to explore the possibility of settlement through mediation in matrimonial dispute. So this is the mandate of Honorable Supreme Court of India. This is the mandate. So now we have on one side Dastane versus Dastane, and on the one side we have Deepa Rao. Both lay down same principles of matrimonial dispute. It's not different. Every time I get a dispute, I go back to Dastane and I get a new insight into the matrimonial dispute. As it is said, mediation is the most appropriate dispute resolution system for matrimonial matters, because it tries to bring about something different in a party. How is it different? That is what we have to consider. This is an interesting article that appeared this year in April 22 newspaper, a matter before the Honorable Supreme Court of India, and certainly advocates could be happy. They found that in one erring couple, there were about 60 matters between them filed by each one of them, against one of them, some 60 matters pending between 30 years of marriage and 11 years of separation. So think about one matrimonial dispute. We saw earlier that escalation of disputes, or that aspect that is there. So 60 disputes, now we generally have 6, 7, 8 disputes, 9 disputes. Some days will come by where we'll have 30, 20 disputes per matrimonial disputes that you want to solve. Why adversarial system, or what we call it as regular judicial system, does not address the system? I take up a case, a small example, where there is a case of recovery of maintenance amount. If that case is filed before this court, what would be the decision in the court? What would be the considerations before the court? I think the consideration is what are the arrears and how much amount is to be paid. If there is a question of enhancement, why it is to be enhanced, whether the cost of living has gone up, some additional charges have been gone up. Mediation goes something better. It goes into the social and economic issues of the parties. The views of the parties regarding to life are more important, and they are addressed to in this. I had a dispute before during my practice days where both of them earning at that time around 20 years back. They were all postgraduates, computer specialists, earning salary in lakhs. And the dispute that arose was की पौर्णिमेला पुरणाच्या पोळीचा प्रसाद बायकोनी का करून द्यायचा, तिनीच का करायचा, ह्याच्यावरनं जे वाद वाढले. आणि दास्तानेमध्ये पण बघाल तर एक छोटा इश्यू तपासणी करायची की नाही हा वाद झाला. आपण त्याच्यावर परत पुढे बघू. Views of the two parties regarding the institution of marriage in particular. This is an important aspect that we have to consider, because how you consider a marriage, whether you consider it as living together, how do you want, like the earlier example was that the husband wanted to take care of the family, and the wife, he didn't want the wife to work because he wanted to take care of the family, and wife thought that the husband was being reserved and he was not taking care of the family. Sentiments, domestic abuse are there, sentiments are involved, social compulsions, personal liabilities, responsibilities of the parties, and securities of future life. These are various issues which are not taken together generally in our adversarial system, but which are taken well care of in mediation. Mediation generally matrimonial disputes arise because there is loss of communication and ego issues. The loss of communication results in absence of exchange of information, ideas. विचार जर एकमेकांशी आले नाही तर तुझा काय प्रॉब्लेम आहे, माझा काय प्रॉब्लेम आहे, मला काय पाहिजे, तुला काय पाहिजे, हे विचार कधीच येत नाहीत आणि त्याच्यामुळे वाद वाढतात. एक छोटा किस्सा होता मीडिएशनमध्ये झालं. एक मोठा डिवोर्स ऑफ प्रॉपर्टी, खूप प्रॉपर्टीज होत्या त्याच्यात. प्रत्येक प्रॉपर्टीसाठी नवरा बायको वाद घालत होते आणि शेवटी बऱ्याच वेळाने ते मीडिएशन कसं तरी सक्सेसफुल झालं. नवरा बायको दोघं हुश करत बाहेर आले. एक दुसऱ्याला म्हटलं अरे मीडिएशन संपलं, मीडिएशनमुळे आपलं मॅटर झालं. ते एक पार्टी दुसऱ्या पार्टीला म्हटलं हे मीडिएटरने जेवढं ऐकलं तेवढं जर तुम्ही 10% जरी ऐकलं असतं तर आपण डिवोर्सला गेलो नसतो. So that is how communication loss is there. So you have to have that loss of communication is addressed in mediation. Now mediation, as I pointed out, it gives it this. Now there is one dispute, one important aspect that is there, that matrimonial contexts and disputes are deeply general species and can be sites of grave power imbalances. हा एक प्रकार जो आहे तो फार महत्त्वाचा प्रकार राहतो की मीडिएशनमध्ये कोणीतरी गैरफायदा घेऊ शकतो कॉम्प्रोमाइज करायला. आणि माझ्या मीडिएशन बद्दल मी हा वाद उपस्थित केलेला, म्हणजे एक माझा डाऊट उपस्थित केला की कुणालाही मीडिएटर अपॉइंट करता येईल. जर कुणालाही अपॉइंट केलं, कुठल्याही बाईला जर कुठल्याही मीडिएटरला अपॉइंट करून 2 सह्या घेतल्या तर तिथं पॉवर इम्बॅलन्स असतो. गावातली जर बाई एखादी, तिला काहीच सोर्स नाही, तिला फॅमिली सपोर्ट नसेल तर नवरा त्या बाईला काही देणं करत नाही. काय करायचं ते कर, मी बघून घेईल म्हणतो. कारण त्याला माहिती आहे 2 वर्ष 3 वर्ष ती हे सांभाळू करू शकते लिटिगेशन, त्याच्या पलीकडे जाऊ शकत नाही. हे पॉवर इम्बॅलन्सेसमध्ये मीडिएशन फार सपोर्ट करतं. एक साधं उदाहरण होतं माझ्याकडे, मला खूप त्रास झाला त्या मीडिएशन कन्सेप्टमध्ये. 2-3 दिवस खूप त्रास झाला. एक डोमेस्टिक व्हायलन्सची केस आली होती, त्याच्यात मीडिएशन सुरुवात झाल्यानंतर 2-3 सेशननंतर ती बाई मला परत जायचं म्हणत होती. मग काय झालं बाबा, तर शेवटी जेव्हा बोलायला लागलं तर तिने पाठीवरचे तिला आलेले वळ दाखवले आणि ते वळ बघून मला लिटरली 2 दिवस झोप नाही आली. आणि ही 2 वळ पाठीवर असलेले, एवढे वळ असलेले पाठीवर, ती बाई म्हणते नाही मला त्याच नवऱ्याकडे जायचं आहे, त्याच नवऱ्याकडे मला राहायला जायचं आहे. मग जेव्हा ते गोष्टीचा विचार करायला लागलं, तिला विचार करायला लागले, त्यावेळेला ते आलं की तिला बाकी कोणी सांभाळणारं नाही, तिला बाहेर काहीच आधार नाही, तिच्याकडे शेतीवाडी नाही. म्हणून ती म्हणते की मला आज कोणी नाही, माझ्या मुलाबाळांना सांभाळायला कोणी नाही, मी काही झालं तरी मी मरेल पण माझ्या नवऱ्याच्या घरीच मरेल. हा एक इश्यू कुठेतरी राहतो. तो पॉवर इम्बॅलन्स कुठेतरी मीडिएशनमध्ये ॲडजस्ट होतो आणि मीडिएशनमध्ये ह्या पॉवर बॅलन्सला ॲडजस्ट करून हे केलं जातं. मीडिएशनमध्ये कॉम्प्रोमाइज म्हणतात, बट मीडिएशन इज नॉट कॉम्प्रोमाइज ऑफ व्हॅल्यूज or of giving up of values, but it is acknowledgement of values and the recognition of the rights of the parties. Now, एक परवाच आमच्या सुराणा साहेबांच्या यवतमाळचा एक पेपरमध्ये आर्टिकल आलं, कलेक्टर ऑफिसमध्ये रजिस्टर ऑफ मॅरेजेसचं कार्यालय आहे. तर तिकडे काही कलेक्टर ऑफिसमध्ये म्हातारे कोतारे जुने वयस्कर लोक बसलेले होते आणि एक जोडपं त्या रजिस्टर ऑफ मॅरेजच्या कार्यालयात चाललेलं असतं. तर ते एक म्हणतात कुठून चालले, तर ते म्हणले नाही ते लग्नाला चालले. अरे लग्न करते काय, केस भरपूर आहेत. तर ते म्हणते नाही बाबा, आता जमाना बदलला, आमच्या वेळेला बालविवाह बंदी होती. आता परिस्थिती अशी झाली आहे की मुलं मुली एवढी कंडिशन जातात, हे पाहिजे, अशी मुलगी पाहिजे, असा मुलगा पाहिजे, इथला शिकलेला पाहिजे, याच ह्याची पाहिजे, त्याचीच पाहिजे, तोच पाहिजे, की आता जेव्हा लग्नाला जातात तेव्हा बालच नसतात. राईट. तर हे विदाऊट बाल एक खूप कंडिशन्स, कारण आता एक वेगळे वेगळे जाणीव झाली आहेत, आपले राईट्सची जाणीव झाली आहे. जुन्या काळात काय होतं की आपला वाद संपला तर सगळे वाद संपतील. आता असं नाही आहे, आता बाकीच्या गोष्टी संपल्या तर आपला वाद संपतील. आधी आपण प्रयत्न करूया हा प्रकार होता. आता सगळेजण म्हणतात की आता किती काय होणार, काय मिळणार, मला काय देणार, मला कसं होणार, मला किती द्यायला लागेल. तर एक थोडंसं वेगळे विचार आता झाले आहेत. आता जसं एक लिटिगेशन होतं नवरा बायकोचं, आता 60 लिटिगेशनचा हे आहे. का झालं असं, तर थोडंसं एन्व्हायरमेंटमध्ये चेंजेस झाले आहेत, सोशल एन्व्हायरमेंट झाले आहेत, प्रगतीचे वेगवेगळे आहेत, साधनं वेगळी झाली आहेत. एकाचे अधिकार, एक चांगला फायदा पण आहे, त्याचे काही दुष्परिणाम असतात किंवा काय वाईट असतील किंवा चांगले असतील, पण आपल्या हक्काची आपल्याला आता जाणीव झाली आहे. हक्काची जाणीव असल्यामुळे प्रत्येक हक्कासाठी माणूस भांडायला लागला आहे आणि ते हक्क मागायला लागला आहे. त्याच्यामुळे एक्सपेक्टेशन्स आहेत, जास्त एक्सपेक्टेशन्स राहिले आहेत. आणि आता आज जगात लो डिग्री ऑफ टॉलरन्स आहेत. मुंबईत असताना एक फॅमिली ओळखीची होती आमच्या, ते सकाळी 6:30 वाजता लोकल पकडायची, 8:30 वाजता त्यांना ऑफिस 9 वाजता जायला. 6:30 वाजता लोकल पकडली, जाता जाता कुठेतरी नाश्ता करायचा, 8:30ला ऑफिसला जायचं, ऑफिसच्या कॅन्टीनमध्ये जेवायचं, संध्याकाळी येताना 8 वाजता परत स्टेशनला उतरलं की एकतर नवरा पोळी घ्यायचा किंवा बायको पोळी घ्यायची, नवरा भाजी घ्यायचा कुठून, म्हणजे होममेड फूड घ्यायचे आणि घरी येऊन झोपायचे. काय लाईफ होतं माहीत नाही. एक्सपेक्टेशन्स खूप आहेत, मला घर पाहिजे, मला हे पाहिजे, मला ते पाहिजे. एन्जॉय किती करू शकतो हे माहीत नाही. पण त्याच्यामुळे लो डिग्री ऑफ टॉलरन्स झाली आणि ह्या गोष्टी खूप बदलल्या. जेव्हा मॅट्रिमोनियल मिडिएशनमध्ये काय इश्यूज राहतात, चॅलेंजेस, तर पहिल्यांदा आम्ही जेव्हा मिडिएशन सुरुवात करतो आणि विचारतो काय प्रॉब्लेम आहे, कुठं काय प्रॉब्लेम आहे, मला काहीच प्रॉब्लेम नाही. त्यांना विचारा काय प्रॉब्लेम आहे, दुसऱ्या पार्टीला विचारायचं का बाबा काय प्रॉब्लेम आहे, काही प्रॉब्लेम नाही, आम्हाला काही प्रॉब्लेम नाही. मग त्यांना प्रॉब्लेम आहे. म्हणजे हा 5-5 वर्ष 6-6 वर्ष कोर्टात कचेरी करतात, त्याच्या आधी 2-2 वर्ष कुठेतरी भांडलेले असतात आणि आपले येऊन सांगतात आमच्याकडे काहीच प्रॉब्लेम नाही. मग कशाला भांडताय, मग कशाला एकत्र राहू शकत नाही. कारण त्यांनी स्वतःचे अधिकार आणि स्वतःचे वाद ह्याला स्वतःला आंधळं करून घेतलेलं आहे किंवा बघायचं नाही हा एक विचार केलेला आहे. तर पहिल्यांदा आम्ही डिनायलच्या स्टेजला असतात, किंवा तू हो म्हटलं तर मी नाही म्हणणार, तुला पोरं पाहिजे तर मी पोरं देणार नाही म्हणणार, तू 100 रुपये मागितले मी देणार नाही म्हणणार, तू देणार नाही म्हटलं 100 रुपये देणार, मी 10,000 मागणार. कितीतरी प्रकरणांमध्ये असं आहे की नवऱ्याकडे पैसे नाही आहेत किंवा बायकोला पैसे आहेत सबसिस्टन्स, पण लोक म्हणतात की नाही मला एवढेच पैसे पाहिजेत तर मी करणार, मला एवढेच पैसे मी देणार. दोन्हीकडे आहेत ते तिथे, कारण तिथे कॉम्पिटेटिव्हनेस आलेला आहे. तिथं यू ऑर मी असं पाहिजे, तू जगशील किंवा मी जगेल, तर आपण नाही. आणि नंतर तिसरं कॉम्प्रोमाइज, आपण दोघं, तू आणि मी, हा एक येतो. आणि हा कॉम्प्रोमाइज कुठेतरी चाललं जातं. आणि शेवटचा म्हणजे मिडिएशनमध्ये आम्ही कोलॅबरेट करायचा प्रयत्न करतो. Collaboration is the last and most effective object that we can achieve. I don't say collaboration means bringing back the parties together to stay. A classic example was there in one of our cases in the recent times, where one of the divorced actors couple came to stay under one roof for their children during the COVID periods. I think that is what we call it as collaboration. Parties forgot their disputes or they had adjusted their disputes and come for collaboration for their children's sake. Now what we propose is that there should be, as a mediation, there should be two different concepts we have to understand. A mediator has to understand that rural issues of mediation in matrimonial mediation and matrimonial circumstances are entirely different than urban cases. In some areas I found even stating for divorce was a very ॲडवर्स इफेक्ट. ते म्हणायचे आम्ही जर घटस्फोट असेल तर ती बाई म्हणायची आम्हाला कुठल्या लग्नात बोलवणार नाही, कुठल्या बारशाला बोलवणार नाही, कुठल्या कार्यक्रमाला बोलवणार नाही. भले मला तुम्ही 10 लाख रुपये द्याल, 50 लाख रुपये द्याल, पण मला जर समाजातच स्थान नसेल तर त्या पैशाचं मी करू काय. सो दीज आर व्हेरियस स्टेटस, rural and urban conditions that we have to consider. One aspect that I feel that we should have mediators, and we should have every person has an aptitude for same. Some have aptitude for good listening, some have aptitude for good speaking, some in mediation we require good patience. And it is not that everyone has that kind of patience to listen to a party. In mediation it requires a lot. It requires a lot of emotional control and patience. So it is necessary that we identify mediators who have that kind of aptitude and assign them these matters of mediation, of matrimonial mediation. Mediation has now evolved into different fields. Now mediation can be of only for persons who want to come together. Mediation if persons have decided to separate. So there are different terms of mediation and they are handled by different persons and it requires specialization. Like taking care of child custody, it requires special knowledge about the child welfare. It requires special knowledge about the education. I think these special provisions or special training or special kinds of mediation should be promoted and taken up besides our regular general training that is being taken up. One part that always refers is in many mediations we find that we cannot take assistance of external resources. For example, I'll take a case where parties allege impotency. As a mediator, I cannot refer them to a doctor and say, get a certificate and then we'll see what happens. If these resources are brought together under the umbrella of mediation, with that confidentiality that a mediator's communication has to these external resources also, we can send these persons to these external resources. Like we have many issues of physical relationship. We have specialized in office persons in them. We have psychologists who are specialized in matrimonial this. Parties can be referred to them pending mediation with confidentiality. If we, again I'll go back to Dastane. In Dastane's case, the entire thing erupted because the husband took the wife to a psychiatrist and then the entire issue of Dastane and Dastane came up. Similar case, if it would have been a confidential issue, if the parties were told that nothing will happen, this is something which is confidential, it won't go before the court. The parties would be very much willing to take special kind of assistance. And I believe the family judges who are out there and family persons who will appreciate that these physiotherapists or specialists in these matters will be a great help in mediation. These mental health professionals or health professionals will be a great help. Today the world has become small. Marriages are performed by an Indian with an American or a European girl with an Indian girl. What laws are applicable to such marriages? A child is born in Spain. Marriage is performed in America. One of the parties is Indian. The second party is British. So all are of different nations and different eventualities. How do you decide such mediation matters or such matrimonial issues? I think this is another field that would require a special attention to be given or special training to be given to mediators to handle these kinds of aspects. So mediation should, I believe that once a party comes to mediation, it should not result that these resources are not available. These facilities are not available with a mediation center and therefore the mediation has failed. I want that mediation, everything that we can do to bring about a settlement should be available under the mediation settlement. This is because parties, the second part which my learned friend also highlighted is time. In India, parties approach courts as a last recourse. Before doing anything, there are people who have, other panchayats have mediated, the relatives have mediated, the friends have mediated. Many other people have mediated in that dispute. And it is as a last recourse that they come to the court. Unsolving or unruffling all that takes a time. Parties' initials also take time. And therefore, sometimes it appears that 90 days period is very less to deal with mediation cases. Also, it involves number of cases like divorce, custody, property, and other aspects which each constitute a different mediation dispute. So it takes time. So if required, and if the mediator so wishes, extra time should be permissible, at least in matrimonial cases. These are my views or my suggestions about what can happen for a better matrimonial issues. Lastly, but not the least, one more thing that was just came up before it, that as two spouses went to a family doctor and they said, तुम्हाला जर राग आला, तुमको अगर गुस्सा आया तो चिट्ठी लिख देना और उसको जला देना. जाते वक्त तो दूसरी पूछती है, चिट्ठी का क्या करना है? If you get it, it should not happen that चिट्ठी का क्या करना है और उसको जला देना. ऐसा नहीं होना चाहिए. Mediation should be चिट्ठी को जला देना है और उसको रखना है. Thank you very much.
सहजीवन म्हणजे एकमेकांचे सूर जुळणं, परस्परांना फुलवणं आणि एकच गाणं दोघांच्या मनात उमलणं. माननीय सुब्रमण्यम साहेबांनी हे सूर न जुळल्यास मध्यस्थाची भूमिका कशी महत्त्वाची ठरते आणि मार्ग कसे काढावे याचे अतिशय सुंदर मार्गदर्शन केले. धन्यवाद सर. Now we are proceeding towards open house discussion. Benjamin Franklin has once said, "Tell me and I forget, teach me and I remember, involve me and I learn." Therefore, the best way to learn is to get involved. I humbly request to all to participate in this open house discussion. I request all the dignitaries, the speakers and participants to start discussion on these topics.
Please feel free to
Hello,
ask.
good evening. I am from Small Causes Court, Mumbai. My name is Uttam Parmar. I want to ask one thing, that is there is any different parameter for solving a problem in mediation for money matters and property matters?
Your, hello. I would like to try to differentiate between two. The first aspect is the property matter in a family and money matters have two different areas of negotiations or approach to the problem. The property matter or in a family matter, you need to have a very personal approach with each of the party to understand their feelings and their understanding. In money claims or commercial matters, one has to consider the entitlement of each of the party and whether we can reach a solution for the purpose of settling the claim in a commercial way. You have to be a very professional in understanding the issues involved and resolve them by asking the parties to do the needful or consider the aspects where they can reach they can resolve their issues with a win-win situation, or they feel that yes, I lost something which was not at all a loss, but I earned something in this particular settlement. So the approach to the commercial matters and approach in the family matters would be definitely different.
Thank you,
I
Senior
can just-
Advocate.
I can just add to this. For example, commercial matters, no emotions are involved in this. Whereas if you take a matrimonial dispute, it is basically two families or two husband and wife, children are involved. So several other factors you really need to take into consideration. Your approach in settling these matters, matrimonial dispute, is entirely different from settling a commercial dispute. Because when you're dealing with any dispute for that matter, you have to understand the nature of the dispute and then think how you are going to go about it. So once you understand the nature of the dispute, then your approach to tackle with this dispute changes.
Thank you very much. We will keep it in mind while solving the problem of a property matter. Thanks a lot.
Any other query or question, please?
Good afternoon. Two speakers just now have expressed that the time limit, there should not be a time limit for mediation. But we generally experience that mediation is being used, the process is being used for delaying the matter. Therefore, we will have to keep in mind that what much time limit there should be. We cannot say that there should not be any time limit.
Before I hand over the mic to learned advocate, I would only like to add here that there is a time frame, and I agree with you that the courts cannot allow the litigants to utilize or to use this mediation process as a tool to abuse judicial process. So there is a fixed time. But in a deserving case, if the mediator feels that the matter is likely to be settled, certainly this time can be extended. But as a general rule, that in every case, the litigants can avail as much time as they want, that should not be encouraged, in my view. You would like-
Yeah, I agree with the suggestion. There is no difficulty about it. I am not saying that there should not be any time limit, but every issue or every dispute has its reasonableness and reasonable time frame. So therefore, for example, I'll just give an example that one of my colleague was dealing with a family matter in which issue of a psychologist, test by psychologist was very important. And time and again, the psychologist had some limitations in disclosing all the things. Mediator wanted to know what are the issues, and psychologist said it is not possible to disclose the issue. But unless mediator understands this, those particular issues, mediator was unable to proceed further, and that is how it took longer time, more than 90 days, or rather more than 180 days. I am not suggesting there should not be any time limit, but I am suggesting that there cannot be an approach of the court that you decide in particular time, otherwise you should give a report which is a failure report. Sometimes it is at the last moment the parties come together and resolve their issues. So therefore, allow them to have their liberty and allow them to resolve their issue in a reasonable time. That's what I want to say.
Thanks a lot, sir. Now the correct terminology has come. It should be the reasonable time. Thanks a lot.
I think we should proceed forward. In this open session, we have experienced exchange of ideas, and our knowledge on the topic has certainly increased. Thank you all. Nari Samajasya Kushal Vastukara means woman is the skilled architect of the society. Today we are privileged with the presence of such skilled architect of law, Honorable Ladyship Srimati Justice Anuja Prabhudesai, Judge, Bombay High Court. I kindly invite Honorable Ladyship to extend her concluding remarks for the third session.
Learned members on the dais, Honorable Justice Gangapurwala, Honorable Justice Nitin Jamdar, my sister, Honorable Justice Bharti Dangre, learned judges from District Judiciary, learned judges from family courts, civil courts, all other dignitaries, law students, members of the registry. In fact, we have come a long way from explaining to the litigants, explaining to the advocates, explaining to the public at large the importance of mediation. From explaining the importance, today we are at a stage, we are exploring the possibilities, exploring the possibility of how we can make this more effective through new concept and new approach. In fact, this itself, I suppose, is a great success. In fact, disputes are inevitable in any given society. What is essential is that our firm resolve to resolve these disputes amicably. As all of us know that the court process is long drawn. We may not be happy about the situation, but that is the reality. So what is the other option? The other option is alternate dispute resolution. Now, mediation is one of the best options because it doesn't require the consent of the parties. The mediator, who is a trained mediator sometimes, or any other person of the choice of the litigants, can ask the parties or can interact with the parties and ensure that the parties arrive at an amicable solution. Now, apart from having our own Advocate Patil has mentioned that there are several drawbacks, or rather he has said there is lack of infrastructure. These are, of course, teething problems. We will overcome these problems. You have mentioned about lack of facilities such as video conferencing, stenographer, photocopy machine. These, of course, are not such major issues that cannot be tackled. What is the major issue, or what is the issue actually, is the change of mindset of the litigants and of the lawyers. As rightly said by Advocate Patil, lawyers play a very, very important role in mediation process. So we need to sensitize them. We need to sensitize our judges. We need to explain to them once again how important it is for the parties to come together. Whether, especially now in the last 2 years during pandemic, due to the outbreak of COVID-19 pandemic, courts, though not closed, we were not able to dispose of the matters as we would have otherwise liked to dispose of, which has resulted in quite a backlog. Now, in such situation, the question posed by Advocate Patil was whether online mediation, whether it can be successful. Now, as I just said, there are several types of litigation. We have commercial litigation, we have matrimonial disputes. It may not be as effective as in matrimonial dispute as you can in commercial dispute. As I said, where there are no emotions involved, where it is just a question of money. Very often I say, now MACT matters. The law is so well settled. Why can't these matters be settled? Why can't these matters be even settled at pre-litigation stage? In fact, the Honorable Supreme Court had suggested in judgment of M.R. Shetty, if I'm not mistaken, that attempt should be made to dispose of these matters. M.R. Krishnamurthy versus New India. But till today, we have not reached that stage where such decisions are taken. We have decisions right from Salim Bar, we have decision of AFCON, we have decision of Krishnamurthy, we have decision of K. Srinivas Rao. But till today, we have not been able to achieve at least as much as we would have liked to have achieved. So what is the approach? Yes, today as and when it is done, as and when we have pre-litigation scheme, as and when these modalities are completed, the rules are framed, laws are enacted, should we wait for it, or should we go on? Should we move ahead with this, with whatever resources which are available with us today? So for that reason, the first step is of referring a dispute. A referral court for this plays a very vital role. Which are these cases which need to be really referred? Which are the cases which should not be referred? Sometimes a settlement can be more disastrous to either of the parties. Just in the morning, our Chief Justice gave an example. You cannot share a painting without destroying it. There may be several such cases where you cannot really bring the parties to an amicable settlement without damaging something somewhere. So for this reason, we should be aware of which cases we can refer to a mediator. So this is a very important role played by the referral judge even before the mediation starts. And for this, the judge should be well aware of the facts, which cases, Negotiable Instrument Act. These cases can be settled if there are no really serious issues involved, no serious defenses involved. Identify those cases. MACT matters pending before claims tribunal. Land acquisition cases pending before the reference courts. Family cases, custody matters. Property disputes, especially boundary dispute cases. I mean, these cases really do not need long drawn process. Recovery of money. Many a times, the litigants only want time to make the payment. Identify these cases, refer those matters to the mediator. And the mediator, of course, has to settle this matter, mediate within a reasonable time. We cannot allow the parties to utilize this mediation process as a tool to abuse the process of law, and we have noticed that it happens very often. In fact, I can just share my experience. In one of the matters, as I just commented, I expressed my view. The husband realized that the matter may not go in his favor. He understood what my view was, and immediately the husband agreed for mediation. It was suggested, I would like to settle this matter. Wife also agreed, and the matter was referred to mediation. And I was subsequently told by the mediator, this was only the husband wanted time so that my assignment changes, and the wife was so sure that the matter would be in her favor that she refused to agree to any of the terms. So these are those small hitches, maybe knowingly, unknowingly, I expressed my view. It was spontaneously done. But the litigants were quite sharp and intelligent enough to use this to delay the process. So this is when we have to understand which are those matters which need time. There will be several matters where we have to extend time. There may be matters where both parties are genuinely serious about settlement, and the mediator is unable to settle it within a given time. It is in such cases, the court certainly will extend the time. Secondly, what we have to also understand is that when the matters are mediated, that the agreement, that the terms which are signed by the parties are lawful terms. It can be settled within the parameters of four corners of the legal provisions. Another example which I will give. There are many a times collusive suits filed. A father files a suit against the son and the daughter-in-law for eviction. The matter is referred to mediation, and in the mediation, the terms which are settled, what is actually resolved is the matrimonial dispute between the husband and the wife, throwing out the wife and the children, lock, stock, and barrel. So this is also one of these issues which we need to consider, that these are the problems which are faced. The party may not know, the litigants may not be aware of their rights. So when the mediator in such cases and the judge who decides these cases has to be very, very sensitive to these needs. Advocate Patil spoke about pre-litigation mediation, whether it is only a formality to be completed. I wouldn't think so. In fact, under Section 12A, Brother Judge Jamdar has already taken a view that it is not an option of the party. It is not an option. It is a mandatory provision which you need to comply with, which you need to abide by. And if we consider and if we think it is only a formality, the whole object will be lost in this. Now, the only problem is we have pre-litigation mediation in very few statutes. We do not have such law or such rules in many other fields, many other cases which could have been decided. We can only hope that it will see the light of the day very soon. As far as matrimonial disputes are concerned, Learned Judge Subramaniam has said that there is a change in matrimonial dispute, there is delay in adjudication of matrimonial dispute. The consequences of matrimonial dispute leads to escalation of bitterness and escalation of litigation. He gave example of how one dispute can give rise to several legal proceedings. We have to understand that marriage becomes a basis for a family, and the family units are the foundation on which society is formed. So when we save one marriage, it has some impact on the society. It's the family which we try to save, and this family, the impact is on the society. The children are the worst sufferers in this matrimonial dispute. So when the matrimonial disputes are filed, there is of course a provision which requires the judge to ensure that these matters are resolved at the earliest through mediation or through any other ADR system or counseling or mediation. There is power of imbalance, no doubt about it. It is there in every litigation. But that is where, as I said earlier, the mediator has to be sensitive. We as judges have to be sensitive. And it is for us to understand whether whatever compromise, whatever agreement they have arrived into is whether it is lawful, whether it can be acted upon or not. So awareness of rights, expectations, degree of intolerance, these are some of the reasons why we have matrimonial dispute. Today we have nuclear family. Earlier we used to live in joint family. Whatever the dispute between husband and wife was always sorted out by the elders in the family. Today the husband and wife both are earning members. Maybe we do not have enough time to give to the family. There are no elderly members in the family who can counsel the couple. So these issues start with very trivial problems. The matrimonial dispute starts with these trivial issues, and which then leads to several other problems, litigation in different courts under different statutes. So solving this matrimonial or resolving this matrimonial dispute through mediation, we not only bring down the number of the pendency or litigation or the cases which are filed by the parties, but we try to bring that harmony, peace within the family. In fact, we have always referred to mediation as alternative dispute resolution. The endeavor should be to see that it becomes a primary dispute resolution. It is only then that we can really say that we will be successful, or all these conferences that we have, workshops we have, that has had its positive impact on this. I would just like to conclude with just a few lines which were said by Abraham Lincoln way back. Discourage litigation, persuade your neighbor to compromise whenever you can, point out to them how the nominal winner is often a real loser in fees, expenses, and waste of time. As peacemaker, the lawyer has a superior opportunity of being a good man. There will still be business enough. We can say the same about all those involved in this mediation process. It is our duty to discourage litigation. It is our duty to persuade the litigants to arrive at an amicable settlement. We have to bring to their notice the consequences of this litigation, whether it is a win-win situation or whether, despite having won the matter, they would still be happy and whether it will be really justice in real sense. We have to make the parties realize, initially maybe it is because of the ego, maybe because of that anger, they do not realize, but in this long-drawn legal process, the parties have to incur tremendous expense. It takes toll on their physical health. It is financial burden, apart from mental torture. So it is not only for the lawyers to make use of this opportunity of being a good man, it is for all of us, all those who are involved in this, to ensure that we too contribute to this noble cause. Thank you so much. And
Thank you, Honorable Ladyship, for your thought-provoking and insightful address. May I now request the honorable dignitaries on the dais to kindly occupy the seats in auditorium for the fourth session. Thank you.
बाहेर गेलेल्या न्यायिक अधिकाऱ्यांना मी विनंती करते की त्यांनी हॉलमध्ये यावे. कृपया कोणी हॉल सोडून जाऊ नये. आपण लगेचच चौथा सेशन सुरू करत आहोत. I request my ladyship, Srimati Justice Bharti H. Dangre, Judge Bombay High Court, to felicitate respected Shri P.D. Popat, Senior Advocate, Trainer, MCPC, by offering a sapling. Thank you, my ladyship. I again request my ladyship to felicitate respected Shri Kishore M. Jaiswal, District Judge for Jalna and Judge Trainer of MCPC, by offering a sapling. Thank you, my ladyship. With kind permission of chair, I request respected Shri P.D. Popat, Senior Advocate, Trainer, MCPC, for his presentation on the topic, Mediation, a journey from a state of disharmony to harmony.
Good afternoon, everybody. I would like to just mention that our rishis and munis spent years and years sitting in the caves trying to get that shift from disharmony to harmony. However, for us mediators, it's not such a tough job. And the reason is very simple, that when you want to help yourself, you can't scratch your own back. And when you want to help others, it's very easy. And for us mediators, I will just explain to you in two ways. One, I would like to just give you an anecdote that consider that there is a person walking in the sun for half an hour, 1 hour, 2 hours, and he comes over to you. You don't need to ask him whether he will have tea or coffee. You just need to offer him a glass of water. And notice that change on his face when he finishes that glass of water. Now, this is the analogy that I would like to use for us mediators when we are sitting there in our mediation rooms with the parties. The thing that we can always offer to anybody at any time is just ourselves. And that is sufficient. When we sit with parties, giving our full presence, not even bothering to look at our mobiles or the clock or the calendar, and be just with them shoulder to shoulder, eye to eye, when they are talking about their situation, then that empathy is all that is required to get them to calm down and be able to communicate whatever that they want to say. Today, when we look at certain other areas, then when you are wanting to get a closure, there are several other mechanisms. And when we are looking at mediation, the whole concept is quite different. Here we are talking of collaboration, and more so we are talking of connecting to the self. And when we as mediators offer our presence, that itself is enough empathy for parties to feel very harmonious enough to take things the next step forward. And in my view, once we start with having that first button on the shirt right, where we offer that empathy by just giving our presence and being there for them for the time that they are talking, in my view, that itself is enough to take a lead from that point onwards and get the parties to harmoniously discuss their issues. Of course, they will again come to the second hurdle when the other side starts talking. And when you are with them, you can get them to center themselves and harmoniously take things forward. I know it sounds easy when I talk like this. I know from my experience, it certainly doesn't work that way. We are taught in our trainings that, oh, when one person says you show empathy, I say, I understand. And that person, if that person is a high conflict individual, then he will say, what the hell? What do you understand? Do you know what I am going through? So this is something which is taught in one way, and when you practice it, it's certainly not happening that way. But I assure you, you find ways in how to introduce even that one phrase, I understand. Like, for example, if they say something, you also give a similar instance, yes, I remember, and that would be really frustrating, wouldn't it? You are not at all breaking your neutrality by saying that. In our mediation trainings, we do talk about that also, that you might be doing that, but that doesn't happen. For parties to get to a state of harmony, even to get them to work towards a more wholesome outcome, you do need to first get them centered and get that momentary state of harmony for them to then take the next step. Just one analogy I'll give. I have several dental problems. So my doctor first sprays my tooth, then gives me some local block, then gives me another injection, but doesn't ever give the injection directly. They first do one or two other things. And the same thing is what we do in mediation. We first center them, get them to a state of harmony for the moment, and then get them talking so that they can get a harmonious outcome for themselves and the other. And we can't do much for everybody. In fact, for ourselves also we can't do much. But one thing we can do for everybody is this. Okay, there is one line, कि मंजिल न दे, चराग न दे, हौसला तो दे. And that's what, my friends, I would like to leave you with the thought that we just need to make that endeavor, be centered ourselves and get them also to get to that state of harmony initially, so that they can work with each other and come to a harmonious resolution at the end of the day. Thank you very much.
Thank you, respected sir. With kind permission of chair, I request respected Shri Kishore M. Jaiswal, District Judge for Jalna and Judge Trainer of MCPC, for his presentation on the topic Existing Legal Framework for PIMS and Future Prospectus.
on the dais, Honorable Srimati Justice Bharti Dangre ma'am, my co-trainer from the MCPC, Learned Advocate Shri Popat, honorable dignitaries of the dais. Being the last batsman, it's always very difficult because at the end we have to win this match and having a very much time constraint. But I'll try, considering the importance of the subject, I think all of you will bear with me for a few minutes. We are highly privileged to have on the dais the senior most mediator, Honorable Justice Dangre ma'am, because I'm aware that in the year 2009, which was the first batch in the Nagpur bench of Honorable Bombay High Court, wherein training was being imparted, and madam is the trained mediator and having lot of experience. So I will not be between her ladyship and you all, because we have to hear her ladyship. Now friends, the topic, considering the importance of the topic, if you looked into, at the end of the presentation, I believe that you all will agree with me that this process has given pen, paper, and ink to consumer of commercial dispute to write their own judgment. Now the notion that the ordinary people wants black-robed judges, well-dressed lawyers, and fine panel courtrooms as the setting to resolve their dispute isn't correct. People with problem, people with pains want relief, and they want as quickly, as inexpensively as possible. Now, if we looked into commercial mediation, mediation is excellent for the world of commerce. Its advantages are keenly perceived and appreciated by people in business for whom cost, time, and relationship are of almost biblical manner importance. The need for commercial mediation arises not just from huge pendency of cases, but from the economic effect which commercial disputes can have on the economy of India. Commercial disputes are almost always monetary in nature, which can destabilize the market if they have stretched out too long. Hence, it becomes more important and imperative to fast track the commercial cases through mediation. Furthermore, if we looked into the commercial disputes are solved quickly, then we can improve the ease of doing business index. In fact, India, which was ranked 142 out of 189 countries in ease of doing business, in the year 2014, it climbed to 130 in the year 2016. In the year 2017, the World Bank acknowledged the enactment of Commercial Courts Act as a measure to improve court efficiency by establishing effective mechanism for addressing commercial cases. The 2018 amendment was a measure intended to speed up the disposal of commercial cases, thereby creating a positive image amongst prospective investors that a strong and a responsive Indian legal system. By the year 2020, India stood 63rd position. Now, if we look into the Italian model, the lawmakers appear to have drawn their inspiration from the Italy, which has successfully tackled notorious delay in its civil justice system through effective pre-litigation mediation. The statistics from Italy's Ministry of Justice showed that the pre-litigation mediation has nationwide success of 43.6%. Now, pre-institution mediation and settlement. As the global economic environment has become increasingly competitive and to attract business at international level and further to widen the scope of courts to deal with the commercial disputes, Chapter 3A of the Commercial Courts Act containing Section 12A was inserted with commercial courts, commercial divisions and commercial appellate division of High Court Amendment Act with effect from 3rd of May 2018. Now, by virtue of this amendment, compulsory mediation, pre-institution mediation in a commercial dispute introduced for the plaintiff who does not contemplate urgent relief. Thus, the mediation as an alternative dispute mechanism has identified as workable solution in commercial matters. Now, friends, all of you are aware that recently, in the case of Messrs. Patil Automation Private Limited versus Rakheja Engineers Private Limited, the judgment of the Honorable Apex Court, it was held that Section 12A must be visited with rejection of plaint, because it was held that this is a mandatory provision. Initially, the Honorable Bombay High Court, in the case of Deepak Raheja, delivered by Honorable Chief Justice Nitin Jamdar sir, has also held that it's a mandatory provision. And now the Honorable Apex Court has gone forward by saying that it should be visited by rejection of a plaint under Order 7, Rule 11 of the CPC. Now, same is applicable to all the suits from 28th day of August 2022. Now, all of you are aware of the authorities under this Section 12A is, while notification dated 3rd of July 2018, the State Legal Services Authority as well as District Legal Services Authorities were authorized for conducting pre-institution mediation under this provision. Now, the specified value. Now, this is very, very important. Why? Because by notification dated 3rd of July 2019, the Law and Judiciary Department has specified the value to be of rupees 50 lakh. Now, if we look into this, in Bombay City Civil Court, the suits are being taken up for the value of 3 lakhs. And in rest part of the Maharashtra, it is up to 50 lakhs. No doubt, initially, when the commercial code was enacted, it was for higher value of rupees 1 crore. And now the department has issued the notification of 50 lakh. But if we looked into our experience, it must be reduced to rupees 3 lakh. And let us see how it can be done, because we are having experience of several other jurisdictions. Now the PIMS rules are being framed, which are in effect from 3rd of July 2018. A party to a commercial dispute is required to make an application to the authority in the prescribed form along with the fees of rupees 1,000. The authority will then issue the notice to the opposite party requesting them to appear and give consent for mediation within 10 days from the date of such notice. And the final notice for appearance, opposite party refuses to participate, then the notice remains unacknowledged, then the authority will give the report of non-starter. Now, this has been provided in the rules. Time limit is also being provided, and mediation fees. Time limit, we have discussed in the first session also. Now, for pre-institution, the time limit is 3 months, and it can be extended for 2 more months. Now, mediation fees is concerned. It's a good news for the advocate mediators who are present here, because now the parties are required to pay a one-time mediation fee under Rule 11 to be shared equally as per the quantum of claim in the scale fixed by Schedule 2, which has been ordered by the Current dated 14th of September 2018. Now, this is a very good news for the advocate mediators who are present here. Now, there is an exclusion of time for computing limitation. The period for which the mediation is going on, the purpose of Limitation Act will not be applicable for computing the said time. Now it's having the effect of an arbitral award, because if the matter is settled through pre-institution mediation, the same will have an effect of an arbitral award as per agreed terms under subsection 4 of section 30 of the Arbitration and Conciliation Act 1996. Now, in the Deepak Raheja's case, the division bench of Honorable Bombay High Court, again headed by Honorable Chief Justice Nitin Zamdar, has given a direction to the Maharashtra State Legal Services authorities, and on the basis of same, the standard operating procedure has been framed by the Maharashtra State Legal Services authorities so that we can have the smooth and uniform functioning of PIMS through the state of Maharashtra. And that SOP has been framed. Now presently, whatever the infrastructure are there with the DLSA has to be used. The nodal officer has been appointed. All the DLSA secretaries, young and energetic secretaries present over here, they have been appointed as the nodal officer of this for this implementation of PIMS, as well as in the High Court, the deputy registrar has been appointed. A separate panel has been prepared for this pre-institution mediation, which is maintained by all the ADR centers. Now, one very interesting fact is there that has been incorporated. No doubt we are doing all this mediation in this mediation room, but this SOP provides that with the consent of parties, and this all DLSA secretaries and coordinator may note that with the consent of parties, this pre-institution mediation can be at a private empaneled mediation institution or in a hotel or in a conference hall, subject to charges being borne by the parties. Now, detailed procedure has been provided for this PIMS. I am not going in details as we are running short of time. A separate procedure is being given. What will happen if the parties have not paid the fees? Then what will do if the applicant fails to pay the fee? Then the secretary DLSA or the coordinator will make a report that the mediation process itself is not commenced. But in the cases if the opposite party fails to pay the fee, then the secretary DLSA will issue a report of non-starter. So that is the difference. And this SOP very importantly provides for online pre-institution mediation, because since morning we have seen that that is one of the challenges, but then a detailed procedure is given, and it has been made it very clear that the mode of online institution mediation can be availed if both the parties agrees, and all the directions given on 15th of January 2021 by the committee will have to be followed. Now this also provides what will happen if the parties are absent. The SOP provides only 2 or 3 bona fide attempts if mediator is being taken up, then and thereafter also if the party fails to appear, then the PIMS shall be closed and the certificate will be issued stating that no mediation process is commenced. But if the opposite party fails, then it will be a deemed refusal. So that care we will have to take for. Now one more important aspect which the coordinator of district mediation center can note, that is regarding utilization of mediation fees. A very innovative provision has been given, and because since morning we are discussing about infrastructure for this PIMS, now it provides that if the fees is being paid, fees under rule 3.1 is non-refundable, and it can be utilized by the authorities for maintenance, refurbishment, development of infrastructure, conducting training of stakeholders, publishing advertisement, conducting awareness program. And the advocate mediators, again a very good news for all of you, that even if the matter is settled or not settled, the honorarium is being provided, which states that honorarium of rupees 5,000 from main mediation center and rupees 2,500 in other places, and the details is being provided in the rules. Now, very important fact which I need to put up in this conference is regarding the non-starter outcomes. If we looked into the statistics from July 2018 to June 2022, in the state of Maharashtra, applications under section 12A filed is 14,956. Out of this, 12,620 matters, the non-starter report is filed. So 88% cases or 88% of the applications are non-starter. So this is very problematic because ultimately what is the statement and objects of this complete act and the enactment will come to an end if we do not find out solution for this. So after studying, I find that we can adopt the Singapore pattern. To mitigate this problem, we can borrow the best practices from Singapore, who has realized the true potential of PIMS, which proves the first and very important, because I take this opportunity, I am seeing the Honorable Law Secretary of Law and Judiciary Department is present over here. If we take up this matter, the specified value, which is presently for 50 lakhs in whole state of Maharashtra, it can be reduced to rupees 3 lakhs. And secondly, I may be everyone will question as to how this will happen. Secondly, some rule may be added, or if the matter goes up before the court, like imposition of cost. One may say that on one part we are saying that the mediation is a voluntary process, and how we can say of imposition of cost. But even presently, our Rule 13 of the Civil Procedure Mediation Rules, which is framed in the year 2006, it provides that if the parties do not attend deliberately the mediation center, the court can impose the cost. At par with the same, we can also incorporate something which speaks of the rules so that they may compel the parties to attend the mediation proceeding. Because to my mind, voluntariness, no doubt, mediation is a voluntary process, but that voluntariness starts after entering into the mediation room. That voluntariness is to the extent of outcome or the result of the mediation, but not for refusing to attend the mediation center. And just a future prospects, because here many of the law students are present, advocates are present, and let me share with you that we are now very near to that of this state of America, because in near future, when all these things have been there in the act and a mediation bill which is tabled before the Rajya Sabha, and if it's going to pass, most of you will be in future practicing as an mediation advocacy. So that is one of the future so far as commercial disputes is concerned. But one fact which I would like to take this opportunity to put up before this gathering, that we can have a separate and independent body. I am aware that the DLSA secretaries are overburdened, and if we can have one more judicial officer who is going to look after the mediation activities as a coordinator, and separate independent body, then this PIMS can very well work. And quality infrastructure, no doubt, because if we are going to handle commercial disputes, the CEO of the companies and all the big stakeholders are being, because what I have experienced in one of the matter which was referred to me when I was posted in Bombay City Civil and Sessions Court, the big company stakeholders, COE and all, they come in the court premises, and we find very difficult to accommodate them in those premises. So a good quality infrastructure mediation room should be there for solving all these things. Then our role of commercial courts is very important, because if we looked into what is being observed in Deepak Raheja's case by Honorable Bombay High Court and what is observed in Messrs. Patil Automation, because in one of the matter, and I have discussed with the commercial court judges, a notice of motion is being filed to avoid going to pre-institution mediation. A notice of motion is being filed stating that what is the urgency? Urgency is to attachment before judgment. Now this is to be looked into very seriously, because when the Honorable Supreme Court has already held that it's a mandatory compulsory provision, the commercial court should look into the fact that when it has been observed that the plaint is to be rejected. So here the role of commercial courts is very important, and for that purpose even commercial court judges should be imparted training. At some of the centers, like, because Mumbai is being called, this conference is for Mumbai region also. The Mumbai is one of the commercial capital, and if after considering mediation and the Mumbai place, its overgrowing popularity throughout the world, we can have an international mediation center at Mumbai. wherein we can look into those matters. And just to conclude, the PIMS which has been introduced by the Act along with the rules, they are having most potential. Only thing is that we have to implement it very seriously. The role of judges, the role of secretaries, the role of advocates, the role of mediators, those are very important. And the efficacy of PIMS process can further be enhanced by way of very simple amendment which I have suggested. A movement in this direction would also slow the addition of otherwise amicably resolving dispute to court dockets across Maharashtra. Such a positive outcome, because before I end, I would like to share one thing. Ki any multinational company or any company, if they want to invest in India, they also make a research as to how much time it would take if any of their agreement or anything went in litigation before the Indian courts, and then only they invest it. So these, in fact, are this process or this judicial process for commercial dispute, in fact, affects the economy. And if we want to reach the top position in the ease of doing business, all the stakeholders present over here, our role for this pre-institution mediation, we have to make, and let us commit ourselves that we will make this mediation movement, the pre-institution mediation movement, the online mediation movement, a grand success. Thank you all for listening me so patiently. Thanks.
Thank you, respected sir. अन्नदानं परं दानं विद्यादानं अतः परम् अन्नेन क्षणिका तृप्तिः यावजीवं च विद्यया. In this beautiful Subhashita, it is said that the food we donate lasts for a few moments until we are hungry again. But the skill or knowledge we give to others lasts for entire life. Thus, the knowledge we acquire takes the responsibility of taking care of us for our entire life. With this beautiful quote, I kindly invite my ladyship, Srimati Bharti H. Dangre, Judge Bombay High Court, for imparting such knowledge by her concluding remarks.
My senior colleagues, Justice Ganga Purwala, Justice Nitin Jamdar, Justice Anuja Prabhudesai, my co-panelists, Mr. Popat, Mr. Kishore Jaiswal, all the judges of distinct courts present here in different capacities, the students of law college, and other invitees. I understand the pain of a speaker who has to speak at the last, and I can see some of you packing your bags just ready to leave the auditorium. But I'll not take much time because my job has been done very easy by the two speakers. Mr. Popat has highlighted the background why mediation was initiated and how it is a healthy practice which was adopted in India for considerable length of time, and what we are ultimately doing is just taking it forward, dealing with the different problems which we are facing today. Mr. Jaiswal, who is also a trainer and who has been associated with this movement, has presented a beautiful paper in form of a paper where he has highlighted the entire scheme of pre-litigation mediation, specifically in commercial disputes. And it has rather flown from a judgment of a division bench from this court, of a bench headed by Justice Jamdar, who has in unequivocal terms said that it is mandatory, reversing a view of a learned single judge of the same court, that it is optional. Subsequently, a year later, and to be precise on 17th August 2022, the view is once again affirmed by the Supreme Court that there is no option. And in the word of the Supreme Court, it is said that this is a cooling period which the parties should take before they approach the court. After taking review of the various decisions holding the field, it has been held that it is imperative in nature and it should be followed as a healthy practice. 2 days back, or rather yesterday only, in the Times of India, an article had published which had catched everyone's eye, including me. A data published by the National Judicial Data Grid was highlighted,
and it showed that 1 lakh cases are pending in the lower court in India, which are pending for more than 30 years. Nearly 5 lakhs, and to be precise, 4.9 lakh cases are pending for 20 to 30 years. 28.7 lakh cases are pending for 10 to 20 years. Thus, the total pendency is 34.6 lakhs cases for over a decade. And surprisingly, rather I should not say it is a surprise, after Uttar Pradesh, we are second in the list. As far as Maharashtra is concerned, there are some 2,56,595 cases pending for last 10 years. And about 10 years, we have some 3,38,482 cases. I think I was awestruck by this data and to find that Maharashtra is second in the place. Now, I don't want to suggest that looking to these figures, we should approach more towards mediation. We have seen that long back, after the amendment came, it's high time that the arbitration and the alternate dispute mechanism was resolved by adding section 89A to the Code of Civil Procedure. And after that, Salem Bar Association, it slowly, all the momentum was picked up. We first shifted to arbitration, conciliation, and the focus is now on mediation. Now, why do we go for mediation? Or why do we encourage people to go for mediation? Is delay only the cause? Or that looking at the figures that people are losing faith in our system? That's not the answer. The answer you'll find in the negative. It's not that nobody should take it that because people have lost faith in the system, they want to adopt mediation. On the contrary, though people are ready to have trust in the court, but they all know that with the different hierarchies of the court, the process may be little time consuming. And how much time consuming we have seen. I have given you the data. Sometimes 20 to 30 years also, which may include commercial dispute, matrimonial dispute, civil disputes. Now, delay may be one of the cause. Another reason may be the money that is required to be spent during this entire journey. The third may be the bitterness between the parties, whether it is a family dispute, still the parties are we know how bitter they become. Two brothers, when they are fighting a battle, civil suit, when they come to the court, they enter through different entrances. We see in a matrimonial matter, husband sits at one corner, wife sits at the other corner. So much is the bitterness when they are litigating. This result ultimately in mental trauma, losing of mental balance, that anxiety, and as if court battle becomes their only last motto of life. And when you see such parties entering into the court of mediator, they find a great solace. They say, oh, alas, somebody is here to hear me. Ultimately, what do a judge do? The whole process of court proceedings is based on patient hearing. When we are in the seat, you are all judges. When we sit on the seat, you are sitting, taking the dais. What does a judge do? A judge ultimately gives hearing to this counsel, and lawyers are happy that I have been heard. Ultimate motto of delivering justice is hearing and then delivering justice. So what does a mediator do? A mediator, apart from giving a hearing, apply his skill and techniques to resolve an issue. Now most of the judges are trained mediators, and we all know the process which is required to be followed. A wonderful role play was played before us, exactly depicting what a mediator will do, and exactly how by the process which is involved, a solution automatically comes. We have seen that the mediator in the role play, we have seen that the mediator initially tried to understand what is the dispute. Then each person, each stakeholder is called independently. His thoughts are analyzed. The mediator little bit tried to pursue the party, saying that look at the other viewpoint also. Look what your brother wanted. Your brother, you can see the mediator telling that your brother has spent so much for you. He sent you for education. He was all the while toiling in the farm. So why don't you consider your brother was also, you should be grateful to your brother. The brothers were told that look at your mother. Ultimately, if your father has left, are you going to leave her destitute? She is your responsibility. You should take care of her. And ultimately, by pondering the thoughts, considering the view of the other side, ultimately a caucus was held. And after the caucus, a solution ultimately emerged. Every party took positions realizing that oh, this I never thought of. I'm only thinking it from my viewpoint, but if I even look at my mother's viewpoint, my brother's viewpoint, my sister's viewpoint, a solution was arrived. So this is something which a trained mediator will do, and easily a solution is worked out. We could see how easy, or we can say the atmosphere was at ease. All the parties were opened up before the mediator. The mediator gave them the patient hearing. She consoled the mother-in-law, she consoled the brother, she consoled the sisters, and ultimately a solution came in with a win-win situation for everyone. Now, if this is the methodology, why don't we invoke it in most of the litigation? Now, as far as we have seen that in family matters, it considered to be the most effective thing, and we had a special session on that. Mr. Subramaniam highlighted that how it would be effective. In the matrimonial matters, we have initiated a program, Let's Talk, or this is in form of a pre-mediation litigation, and the family court judges who are here, who are a part of that program, I must say with great pride that when we put up initially, we had to give a lot of publicity. We put it, the DLSA publicized it, and surprisingly, before litigating, couples walked into these forums and said that, can we be heard? Because we are unable to understand each other. And we have the psychologist, we have Sukun involved into it. So people on their own, the couples have walked and said that, can we be helped? We need some help. Pune is a city where we found that most of the people, we have been able to settle so many disputes before they walk what we say in Marathi, कोर्टाची पायरी शहाण्या माणसाने चढू नये. Before they could come to the court and actually enter into a dispute, lodge the dispute, they found solutions with the help of the counselors. And ultimately what we realized was that they needed to talk to each other. The barrier had to be broken. And when that barrier was broken with the help of a psychologist, a third party, or some other member who is a stranger, but at the same time empathetic to their problem, the solution automatically emerged. We had felicitated many such couples who have settled their discords and are living happily. So this is the miracle of a mediation. Now, considering that mediation can be an important tool, the erstwhile Chief Justice of India, Justice Sharad Bobde, had always in mind that we should have a program, and since Tanu Mehta is here, she is an instrumental in that program. In the Maharashtra National Law University, Mumbai, we have a 2 years LLM program in mediation. And it is not only for law graduates, but we have students from all walks of life who can, it is a postgraduate program, so they can just walk into it, not necessarily with the idea that they are going to be the judges or the lawyers, but they are persons from different walks of life who can make a difference even if they mediate in the members of the society where the discord is prevalent. Not necessarily our aim is not that mediation should take place only when they walk into the court or when they are about to walk into the court, but even in normal walks of life, we find that this mediation would be a success, and therefore we have a 2 years course, 40 students batch. This is, I think, our second year, and it has been a great success. Now, we have seen Mr. Jaiswal has highlighted to you how it can be useful in commercial disputes. Commercial disputes also we can see we have the whole scheme is, I need not repeat it because the whole scheme was placed before you. Here you can find that now we are all ready. When the judgment in Deepak Raheja case from Bombay High Court, we had many questions whether the infrastructure is ready, who will implement it. So the division bench called for the solutions. And as Mr. Jaiswal has highlighted before you that we have a SOP, we have the rules being framed. At present, the authority is with the DLSA, but as the response comes, we are ready for an expansion also. So we should see to it that we make maximum use of this to see that not with an intention that we are unable to cater to the backlog or the pendency, but let in a short possible time before they come to the court, let people have happy endings. And commercial dispute, as Justice Prabhu has rightly said, it is nothing of emotional. Two businessmen, they know what their stands are. They want a mediator to make them arrive at a solution, and automatically they know what is their profit, what is their loss. Even if he compromise on this, ultimately what the effect is going to be on his business. They are wise people. So only thing, they need a channel through which they can they can work out their differences, plus minus here and there, you will find that it will yield into good results. The most important thing is, when mediations come, we always assume at what stage should the mediations are successful. When we take criminal proceedings at the stage when somebody is arrested, 498 or the arrest is, very prominent or is apprehending arrest, then when we tell and we our often chosen mediator is Mr. Patil. So whenever 498A comes, we all go to Mr. Patil. And I must say with pride that at most of the litigation, the mediation are successful. The couples come together, say that we have settled, 498A withdrawn, bail, anticipatory bail, whatever benefit confirmed. They come at appellate stage also. So it happens that it is the stage at which the reference is made that is very important and relevant. Now, I must tell you, yesterday, since I won't mind if I take 5 minutes, if Justice Gangapurwala permit me to take 5 more minutes. Now, yesterday I was just, in the evening, we were just chatting, and I still remember when I was appointed as to undergo the training in 2009, I will just share 2 experiences as a lawyer and as a judge, how it has helped me. Now, in the year 2009, when the initial batch came, and I think it was Justice Khanvilkar who approved the names from Nagpur. So first, me, Justice Haq, we crossed the names and we said, we don't want to go, what is this mediation? He sent the list back and he said, you must undergo mediation. We underwent a mediation 40 hours course. Then gradually we were roped, because at that time, not that there were many trained advocate mediators. So we used to rush and we used to carry out many mediations. Now, of course, it was always with my responsibility as a government pleader. At 4:30, with my mind all occupied, my clients waiting, I used to go to the mediation chamber, sit there for 15-20 minutes, do whatever I could do. Nahi or I khatam, close. But one mediation I will never forget is that I still remember Justice R.K. Deshpande appointed me as a mediator. And he called me in the chamber and he told me that you have to go and do this mediation in Akola. So I was rather surprised. I said, oh my God, this month of May, I'll go to Akola. He said, no, please you do this because this girl is handicapped. She can't move, so you go and you have to mediate it there. I agreed. Ultimately, in the scorching, the vacation was on, so scorching summer season, I went to Akola. It was being held in a lawyer's chamber, in a lawyer's house. And the girl was completely crippled from her bottom. She was in the wheelchair. She was staying next door. She was brought in the wheelchair. And the story was, I lost my heartbeat when the story was told. She was married to a lawyer from Mumbai, and on 6th day, she consumed poison. They went to honeymoon, came back on 4th day, she consumed poison. She was not successful, she was in critical condition, and then she was scared. Second day after that, when she was admitted in the hospital, she jumped from the 4th floor bleeding. The result was this: when she fell down, not a single bone in her body was intact, completely into pieces. So ultimately the husband, he came, the family is a very known family from Bombay. The parents are doctors, they arranged for everything. So 2.5 years this girl was undergoing operation. 2 years she was in Mumbai, shifting from one hospital to other. And somehow when she was brought to Akola, she was all in pieces but somehow tied intact, but still long way to go to recover. So I realized what was the cause. I spoke to her, what is the reason? Why did you take this extreme step? Then surprisingly, this girl came from a conservative Marwadi family. They had no father, somebody else had cared for, there were 4 daughters, and their mother had done their level best to bring up these daughters. The girl told me that, madam, my husband had an affair. I said, what affair? So she said, no, when we were getting married and for the marriage ceremony, all his friends came and they used to hug him. He was smoking, he was drinking, his friends were drinking. I immediately realized that this is a gap between the 2 stations. She was from an Orthodox family, the boy was a very well-to-do family from Mumbai. So hugging, touching each other, his girlfriends being close to him, close proximity, smoking, drinking, that was something this girl was taken awestruck. So when they went for honeymoon, she said, he drank. So for that, it was a cultural shock. And she said nothing, she could not be consoled, and he also, the boy got annoyed, and they ultimately 4th day came back. And then this girl realized that, what do I do? How do I stay? If I'm not able to catch up, I can't tell up my mother also. So she consumed poison. Slowly I realized, then the boy was also called. I realized that the boy said, what gawar out of girl is this? She took it as an offensive. I beating with my girlfriends. I have so many girlfriends. Bombay culture, she is not aware. So I realized this is a case of cultural shock. Second time, when the 2-3 sittings, I realized that they cannot come together. This boy was not ready to accept, and ultimately, even if the girl was brought with him, he said, "मैं रख तो लूँगा, but पड़ी रहेगी कोने में." And that really, I mean, I was taken amazed by this sentence, and I realized that he will live up to this. Because this boy for last 3 years had not even, I asked her, whether he contacted you anytime inquiring about your health. She said, not a single phone call. So I asked this girl, what do you expect from this boy who has not established a single contact with you for last 3 years even to inquire how you are? And what do you expect if you go and stay with him? Would you get any love and affection? So she said, no, madam, I don't expect. I asked her, ascertain it from your heart and tell me whether you have 1% chance that you will get love and affection from this boy. She said, no, madam, I don't expect. Then I roped in her sisters who were matured enough. I asked them, why do you want to send her back? They said, no, madam, he will beat her, he'll misbehave with her. But the real task was when I spoke to a mother, when I told, आपकी बेटी उधर आप भेजो नहीं तो वो उसको कुछ हो जाएगा. So उसकी, the mother asked, तो क्या करेंगे? तो हमने कहा separation कर लो. She was under a tremendous shock. She said, madam, आप क्या बात कर रहे हैं? मैं समाज में क्या मुंह दिखाऊंगी? मेरी और 3 बेटियां ब्याने की है. So I said, don't take it like this. So another sitting, I said, आप सोचो, 2 दिन बाद हम फिर से आएंगे, देखेंगे क्या करना, आप सोच के देखो. Then I had to convince her mother that, look, if your girl, at least today your daughter, look, she's alive. What happens after if you leave her and if she commits the same thing, or if she don't survive this relationship, what would be your, I mean, what would you do? Are you not happy that your daughter is alive? So she said, abhi usko kaun dekhega? Wo kya karegi? So I said, doesn't matter. We'll get some money from the boy so that she was a BMS doctor. You have a big house. इसको यहाँ एक छोटा अस्पताल कर दो. Wheelchair पे जाके hospital में अपने तो बैठ ही जाएगी. So then slowly she said, नहीं, हम हमारे relatives बुलाएंगे. फिर उसके फूफा जी, पापा जी, so many relatives came on the next time. So everybody, some said, no, we can't tolerate. हमारे समाज में divorce नहीं होता है. So I said, समाज में, I had to convince them that, look, समाज में divorce नहीं होता, I understand. But look at the girl. Now the girl by this time was ready. She said, no, I don't want to go with the boy. So after many efforts, ultimately, and the problem is with the boy family, when they came, they said, हमने तो करोड़ों रुपया इसके ऑपरेशन पे खर्चा किया, अभी तो हम 1 पैसा नहीं देंगे. So I said, 1 पैसा नहीं देगी, अभी तो 3 ही साल हो गया, डाल देगी केस तो अभी आप सबके सब अंदर हो जाओगे. Then they also realized, then they started with 10 lakhs. Then नहीं, अभी इसके ऊपर तो है ही नहीं. I said, if now also she goes to the police station and gives a complaint, you are saved. Otherwise, you are all in. Slowly they agreed, and ultimately the settlement was made for 60 lakh. The girl got 60 lakh rupees. Now she is running a clinic, and she is happy in the sense that she can sometimes call me up even now after 7-8 years, and she says that, Madam, mera acha hospital chal raha hai. So this is what the miracles which happen in mediation. But I must tell you that this was happened because I had time, the perseverance to deal, because there were 7-8 sittings I had. And I was also so obsessed that I used to go to Akola often, despite the fact the whole summer vacation I not wasted, but I utilized on this. So this is one story, and another story is as a judge also, we all do. Justice Prabhu Desai, Justice Dere, all the judges of the lady judges of the Bombay High Court. I don't say that the male judges do not do, but we are rather more keen when we are on the matrimonial side, giving up our lunch. We call the couples in the chamber, and the lawyers also often say, ladyship, thoda chamber mein bila lo na, आप बोलेंगे तो कुछ हो जाएगा. So under a hope that we'll be able to do something, we call them, give up our lunch times and try to convince them. So one couple which came to me, both studied in, both were in US. After they came, some discord between them. They were two twins, 5 or 6 year old. And after they came, on the judicial side, I heard the matter a long period of time, and I realized that there is no point. For some reason, the couple could not be brought together. But the whole battle was about the custody of the child. The girl was also from a family at Vadodara, Gujarati family, her father very well-to-do, into good business and all. The boy also was from some enterprising company, earning a lot, a huge amount. Money was not a problem. But the battle had become so bitter, they had 28 litigations pending. So whenever summer vacation, Christmas vacation, access order, rejection allowed, everybody used to go to Supreme Court. So 2-3 times I dealt with this access orders while, because I was a junior judge and I used to take those summer vacation, winter vacation. So all those things I decide, every time the matter went to Supreme Court, sometimes Supreme Court entertained, sometimes send them back. So one day I suggested to them, why don't we settle? So then I realized they can't stay together. So they said, yes, we don't want to stay together for reasons X, Y, Z. We are very clear on that. Only thing is us now the question is about the children. Now, many sittings, we had many sittings. The lawyers, every day they used to bring drafts. The only question was, and the girl said that I want to take care of these children, he must pay some 50 crores. So this man said 50 crores is not possible. So all right, then she came, somehow it happened and something, he said 10 crores. 10 crores, he said, I'll pay, right from in terms of their education. Then one day this girl says that no, he should give in writing that he shall send my children to foreign for education. So I was taken aback after all the terms were settled. Madam, I said, they are 5-year-old. How can you say what is going to happen after 20 years when their time will come for higher education? So she said, no, I want an undertaking. He should arrange and she should give. Then I had to convince her that, madam, look at this. How can you expect, even if it was a normal marriage, who foresee after 20 years? Take a case, for example, in a normal marriage, something happens, a husband suffers an accident, he becomes incapacitated. Can he give a guarantee that he'll, despite this 20 years after, I'll send my children? So I had to convince her, but many sittings, every evening, after 6 o'clock, 8:30, even after the court hours, we used to sit. And one fine day, the girl came and said, I met his parents, they used to come and literally cry for the grandchildren. Her father was very insistent, every time access order, they used to have a camera. And 5 minutes late ho gaya. Madam, last time 5 minute baad choda tha. 5 minute pehle ho gaya tha. So I was also fed up. I said, anyway, one fine day, this girl comes and says, madam, not possible, मेरे को करना ही नहीं है. I said, what's the reason? क्या अपना last time तो decide हो गया ना ये monetary settlement? करना ही नहीं है. She said, I don't want. The boy was insisting. He started crying. Madam, let her, Ishita, tell me the reason why she don't want to do. This girl was adamant. Her father came and told me, nothing, madam, हमको कुछ करना ही नहीं है, बस हम जा रहे हैं. I said, okay. After 2 months, I again went on the same assignment, and one fine morning they came and mentioned that we have settled. So kindly take this matter at 2:30. So I was rather surprised. I said, settled? I was rather eager. I said, bring at 2:30. So 2:30, this girl, this had only what she had accepted was that for some insurance policy for the children and not a single penny taken. Nothing, not a penny. Access was granted, day access, night access after, in summer vacation, Christmas vacation. So they signed the consent terms. 28 matters came to an end. But then the lawyers requested that, ladyship, we would like to, these people want to meet you at 5:30. I said, all right. So they said even the middleman also want to come and meet. So I was very curious to know what changed. I thought that maybe that this girl is getting married or she is now settled, therefore she has loosened her this thing. But when the parties came to me, I asked her, are you getting married? She said, no. So I asked, and those people, there were 2 mediators. Mediators in this, and some Samas people from Gujarat. So I asked them, how did this happen? She was so adamant. So they said, madam, कुछ नहीं, आपने जो उनको धीरे-धीरे उसके मन में उतारा था ना, because I used to always tell this girl that कितना लड़ेगी, how many years you will fight this battle, and ultimately you will have nothing. After 10 years or 15 years, your children will be grown up. When once they are major, they'll take their own decisions. And what are you going to get? So these mediators, they told me that madam, धीरे-धीरे जो आपने बोला था ना, हमने एक ही किया. हमने इनको बोला कि अगर ऐसा हो जाएगा तो देखो समाज में आपकी क्या इज्जत रह जाएगी. आप इतने बड़े हो और उनके नाती पोती के लिए आप पैसे मांग रहे हो. That convinced the father, and he said nothing because he was a rich man. Ultimately, she said only some insurance, medical insurance for the children, limited. She gave up everything, and everything was settled. 28 matters got settled. So I must say that what it requires is only patience, some perseverance, and a good human heart, a capacity to give hearing, and that is what the parties expect from you. I don't think from the mediators we expect something more. It will cut short the time, it shall cut short the expenses, it shall spread some happiness in the community, and we can all contribute to be a happy community. I'm indeed thankful to you. Thank you very much.
Thank you, my ladyship, for your valuable guidance and sharing of experience. I request honorable dignitaries on the dais to occupy their seats in the auditorium. Thank you all.
Now I invite your attention towards valedictory session. It is my great privilege to request my Lord Honorable Shri Justice S.V. Gangapurwala, Judge Bombay High Court and Member Main Mediation Monitoring Committee, Bombay High Court for valedictory address.
Justice Nitim Jandar, Sister Justice Anuja Prabhudesai, Sister Justice Bharti Dangre, the members of the judicial fraternity, the resource persons, and my fellow students. Very good evening to one and all. We started with good morning, and now we would end with a good evening. Well, I'm not a good orator as Justice Prasanna Varale or Justice Bharti Dangre or Justice Anuja Prabhudesai. Valedictory is to say goodbye. It's a farewell speech. But now it has assumed the character of an address. So here I am to perform my duty. At the outset, I would thank the Honorable Chief Justice of the High Court of Judicature of Bombay, Shri Dipankar Datta, for gracing today's function and sharing his valuable thoughts. It is always a pleasure to hear his lordship. Brother Justice Prasanna Varale, whenever he stands up to speak, he mesmerizes the audience with his great oratory skills and knowledge. He has explained the importance of mediation, the steps taken by the main mediation monitoring committee in implementing the mediation programs. Our first working session was on the subject real life experiences in mediation. Brother Justice Jamdar shared his experiences. He aptly put forward the gnosis in a very effective manner. He has given a new insight about the probable litigation that we may face in future and how the mediation can be used as a tool for that purpose. He has asked us to ponder about the litigation arising out of e-transactions, the water sharing disputes. Of course, that would be a need of the hour. All the three resource persons have also shared their nice experiences. I know every case that you people handle as a mediator is unique in its own way. Every time you'd get different experiences, and it was great hearing the experiences of you all. In the second working session, the law students presented a very nice role play. The role play was outstanding. I congratulate them for such an outstanding role play. The said role play was very effective and conveyed what the speeches may also fall short of conveying. It was nicely scripted. Such type of role plays important role in spreading awareness among the litigants and common public. I would suggest that these role plays should also be played in villages, in rural areas, so that they would get educated. In the third session, we covered two topics. First was about new idea, concept in mediation and change of approach. And another was matrimonial mediation, potential challenges and way forward. Sister Justice Anuja Prabhudesai has elaborately discussed about the lack of infrastructure and the innovative ways to use mediation, and discussed about the importance of mediation in matrimonial cases. She discussed about the change of the mindset of the mediators and importance to sensitize them. Mr. Raju Patil is a senior advocate at the Bombay High Court and one of the best mediators we have. His PowerPoint presentation on new concept and ideas in mediation was really impressive and an eye-opener. It would help the participants present here to change the approach towards the mediation. Principal District Judge Mr. Subramaniam has also given important inputs regarding the challenges in the matrimonial disputes, and he has suggested the ways, and they are remarkable. The family structures of various communities may be different, but love and affection and the support that members of a family get from each other is the value of every family. Last working session has also covered two subjects: mediation, a journey from state of disharmony to harmony, and existing legal framework for PIMS and future prospects. Sister Justice Bharti Dhangre has highlighted the roles of various stakeholders and shown a way forward for mediation in commercial disputes and also the matrimonial disputes. She very effectively conveyed the message from her own experience she has garnered the day she was a trained mediator and thereafter also as a judge. It is also noteworthy to note that Sister Justice Bharti Dhangre, Sister Justice Anuja Prabhudesai also sacrificed their lunch time to see that the matters are mediated in their chambers. Mr. P.D. Popat is a well-experienced senior advocate and an advocate trainer. He is also one of the good mediators we have. He has imparted training to many judicial officers. His experience in this field is phenomenal. He has revealed many techniques to overcome the impasses during mediation process. I hope the judicial officers will use these skills to optimum and settle more matters. Another subject was relating to Commercial Courts Act. Amendment to Section 12A, making mediation mandatory. Day by day, we are receiving many applications for pre-institution mediations. We need to provide a proper formalized infrastructure for the pre-litigation mediations, which would handle all the PIMS work swiftly. Mr. Jaiswal highlighted about the comprehensive SOP adopted by Maharashtra Legal Services Authority. I request all the judicial officers to implement the said SOP scrupulously. The main mediation monitoring committee has undertaken steps to strengthen the mediation framework. These steps include development and promotion of pre-litigation mediation programs, strong coordination between the judiciary and the government to implement institutional framework for mediation, high professional standards and adequate training for mediators, education and training of all judges in their roles to refer matters for mediation, and accreditation guidelines for mediators. There is a pressing need to train advocates about the fundamentals of mediation, to improve their understanding of the process and train them for their role in preparing parties for mediation. Recently, we have moved a proposal to the MCPC New Delhi to provide 40 hours mediation training to advocates. If we get approval, initially we shall impart training at regional level, and later on we will arrange such training programs at district levels. Our target is to get more and more advocate mediators to handle swiftly the pre-institution mediations in commercial disputes. Lastly, I would say that it was a great experience for all of us. I'm happy that all the participants have demonstrated true faith and actively participated in the working sessions. I'm sure great memories and familiarity of knowledge for everyone would be the takeaway of today's conferences. Thank you, everybody. Thanking you all.
Thank you, my lord. That concludes remarkable, memorable, and knowledgeable conference. This may be the end of today's program, but undoubtedly, this is the new beginning. We are now equipped with new ideas, different solutions for mediation process, and are now ready to do our best in the mediation field. At the end of session, it is our pleasurable duty to express our deep sense of gratitude towards the people which made this conference a grand success. We, judicial officers at Pune, is a team. A team connotes many hands and one mind. The mind of this team is our Honorable Principal District Judge Shri Sanjay Deshmukh sir. His guiding words always help us to perform our best. Under his able guidance, we could achieve the first rank consecutively for 6 times in National Lok Adalat held across India. Let me invite our family head, Honorable Principal District and Sessions Judge, Pune, Shri Sanjay Deshmukh sir, to deliver vote of thanks.
Good evening, everyone. All the dignitaries of the dais, my esteemed colleagues, brother and sister judges, learned members of the bar, students of law college, and paralegal volunteers present in this august gathering. I deem it a great honor and privilege to propose this vote of thanks on this memorable occasion. This regional conference is memorable because of the valuable guidance of all the dignitaries. Honorable Sri Justice Dipankar Datta, Chief Justice, High Court, Bombay, and Patron-in-Chief, Malsa, has enlightened us on all aspects and facets and benefits of mediation. The guidance of Honorable Lordship will be helpful to the judges and advocates while conducting mediation. I express special gratitude to the Honorable Lordship. We know the tremendous and relentless efforts taken by Honorable Lordship Sri Justice Prasanna Varale in the work of legal aid and its related branches. The work of Honorable Lordship as the Executive Chairman, Malsa, and Chairman of the Main Mediation Monitoring Committee plays very important role. Valuable directions given by the Honorable Lordship from time to time shaped this event. Without His Lordship's support, this conference could not have succeeded. Valedictory address of Honorable Sri Justice S.V. Gangapurwala, Senior Judge and Member, Main Mediation Monitoring Committee, given us valuable guidance. Therefore, my sincere thanks to Honorable Lordship. Honorable Lordship Sri Justice Nitin Zamdar, Chairman of the Mediation Monitoring Subcommittee, High Court Bombay, and Honorable Ladyship Srimati Anuja Prabhudesai, Member Mediation Monitoring Subcommittee, Honorable Srimati Justice Bharti Dangre, Member Mediation Monitoring Subcommittee Mumbai, have summed up their respective working sessions and open house discussion in simple manner. The practical ways to sort out the issues of mediation and lucid thoughts of the Honorable Leadership and Honorable Lordships definitely encourage all the participants of today's conference. Therefore, my sincere thanks to the Honorable Leadership, Honorable Lordship, their address, and certainly helpful to all the participants of today's conference. Sri Mahendra Chandwani, Honorable Registrar General, and had given his valuable time and attended this conference. I express special thanks to him for his constant support and guidance. The resource persons have given minute and detailed niceties to the subject of mediation. I have no words to express my thanks. Certainly, their guidance will be helpful to increase the success ratio of the mediation. We are also thankful to all the Honorable Principal District Judges, Chairmen and Secretaries of all the District Legal Services Authorities for their valuable support and coordination with all the judicial officers at district level. An event of this dimension cannot happen overnight. I'm grateful to the core committee for meticulous planning of this event. Sri D.P. Surana, Sri Ajit Yadav, Sri Todkar, Sri Sitole of the Malsa have coordinated with various committees of the judges at Pune headquarters for excellent organization of this conference by visiting Pune and valuable instructions given by them for making this conference success. I thank them and their team. I also express my special thanks to the anchoring team, Srimati Navandar and Srimati Dolare Madam. We are grateful to the concerned committees for the beautiful decoration and delicious food. All play actors have played their role as an artist of the Hollywood or Bollywood. Their play is a practical guidance for mediators. I thank all role play actors and their team leaders. I thank Honorable Registrars of the Bombay High Court, the head of the City Civil Court, District and Session Court, Small Causes Court, Family Court, Industrial Court, Cooperative Court, Motor Accident Claim Tribunal, Charity Commissioner, School Tribunal, Chief Metropolitan Magistrate, and also thank all the judicial officers who have participated in this conference and all the advocate mediators present here, and also law students who have participated in this conference and helped us in a disciplined manner to organize this conference. I especially thank all the committee heads and the members of the District Judiciary Pune who have taken great efforts since past 1 month for making this conference a grand success. I especially thank Srimati Mangla Kashyap, DELSA Secretary Pune, the entire District Court Pune staff, and who took a lot of efforts for organizing this conference at Pune. Vote of thanks is not mere formality, but it is duty to acknowledge and appreciate the work of all persons who directly or indirectly did the good work for great success of today's conference. Those are Rajesh Deshmukh, the District Collector Pune, who helped in booking all the rest house. Amrut Natekar, Deputy Collector Protocol Branch Pune, helped in all arrangements for rest and guest house booking. Sri Vikram Kumar, Commissioner Pune, Municipal Corporation Pune, who helped in booking this Ganesh Kalakrida Manch and hall with free of cost, and help for arrangement as well as decoration and registration of all the participants. Santosh Warole, Deputy Commissioner, Sports, Municipal Corporation Pune, who provided Nehru Center for made available Nehru Center with free of cost. Amitabh Gupta, the Commissioner of Police, Pune City, who attended the office meeting from time to time and made all the security arrangement, traffic arrangements, etc. Rahul Srirame, Deputy Commissioner of Police Traffic Division Pune, who made traffic arrangement and parking facilities for judges and judges' cars. Kumar Khairnar, Additional Commissioner of Pune Municipal Corporation and in charge office of TMPL, who helped for providing 20 air-conditioned buses free of cost. Advocate Nishat Sawan, who is in fact Chief Legal Officer, Pune Municipal Corporation. Her notable work is certainly become helpful. She contacted Commissioner Office Pune from time to time, made so many arrangements, decorated this hall and other offices of Ganesh Kala Krida Manch, and made all the facilities free of charge. So special thanks for Nishat Sawan, Rushikesh Ganu, Senior Advocate ILS College, who trained 70 students for providing helps to us and all the students of Law College. The officials of the Pune Municipal Corporation, Commissioner Sri Vikram Kumar and his team, who also provided this well-equipped venue, Ganesh Kalakrida Manch, free of cost, and therefore we have enjoyed this today's conference. I thanks once again. With this I conclude. Happy journey to you all. Thanks.
Thank you, sir. I would like to request everyone to stand up for the national anthem. With the kind permission of the honorable dignitaries on the dais and of the dais, I declare that the conference is over, followed by high tea. I request to join high tea after national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंग विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंग तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगल